SJC-12445, Commonwealth v. Richard O'Leary.
Actually, Ryan, doesn't she go first? Isn't the Commonwealth up here? Oh, is that right? Okay.
I had that same thought, Your Honor, but the clerk's office was nice enough to let me know I was going to be going first.
Okay, so you won in the trial court, you lost in the appeals court. It's your FAR, so I guess you go first.
Thank you very much. 3 points that I would like to make. The first, the Commonwealth relies on several cases. Every single case that the Commonwealth relies on, that I rely on, that I have read, the first step in determining whether 90C Section 2 was complied with is an examination of why there was no writing in the first place. Why was there no writing at the time and the place of the incident as required by the statute? In the majority of these cases that have been decided, the issue is the defendant was not present or was otherwise unavailable, and that is why the citation could not issue. In this particular case, there is no reason whatsoever proffered by the Commonwealth why a citation could not have issued at the time and the place of the accident or immediately thereafter at the South Shore Hospital, where Trooper Gray performed his investigation and where he concluded his investigation.
Counsel, I have a memory of the record, and I'm hoping you can correct me if I'm inaccurate, that one of the reasons given was that they were waiting for supervisors to review the report?
The reason that Trooper Gray stated ultimately that he waited to issue the citation after he returned to the station, and the reason that it was 9 days was for that reason. But Trooper Gray was speaking to why 9 days, why 6-week delay, and not why that he didn't give a citation at the time and at the place of the incident itself.
It's not at the incident, at least at the hospital, and that raises the issue of whether Judge Cannoni's finding is a factual finding or a legal determination as it relates to the officer had everything that the officer needed to know at the hospital in order to issue a citation. And
that's accurate, and I think that is already well decided. There are several cases which state that that is a matter of fact. That in Commonwealth v. Kenny, in Commonwealth v. Correa, time and again, the courts have said that the determinations about the particular excuse or not excuse to issue a citation is one of particular facts. To quote Kenny, each case must be decided on its own particular facts. So that's a factual analysis. But here there's no reason. There's just no reason whatsoever. So if you have a statute that requires a writing at the time and the place of the accident, the trooper was there. He could have issued the citation.
Counsel,
Simply chose.
Is this statute a complete defense for your client? So if the citation isn't issued at the time, as you're arguing,
yes,
that's it? So
yes. So the legislature could, and I mentioned this in my briefs, the legislature could not be more clear. It does not say it is a presumptive defense or it shifts the burden to the Commonwealth. None of those things. It says it shall be a defense. It shall be a defense. It could not be.
That's been interpreted with at least 3 exceptions, and I think the exception here, to sort of put it colloquially, is that dismissal wouldn't be consistent with the purpose of the statute.
Yeah, and that's my third argument. If you want, I'll skip to that. But the Commonwealth has argued, as it must, that the purposes of the statute have been otherwise met. It hasn't. The purposes of the statute has not been met three fundamental ways. The first issue with that is that the statute clearly, one of the main purposes of the statute itself is to require a writing. The language couldn't be stronger that the legislature wants there to be a writing. In the scales of justice, a police officer at the time and the place of the accident doesn't have a thumb on the scale of justice. He has a fist to drop down on the scale of justice. He can make decisions about what to include, what not to include, what to charge, what not to charge. He has an immense amount of discretion. The countervailing bit to that is a feather on the scale of justice, which is he just has to record it. He just has to issue a writing. That's the only protection that we have. That's the only countermeasure we have. So I would argue the statute in its main purpose is to require a writing in the first place. Secondly, the other two stated purposes within the statute in and of itself, and the first one is most arguably not met, is that no delay is created to provide that opportunity for manipulation of the process. The reason the statute was created in the first place, there was a 3-day delay where the issuing officer would bring the citation back, give it to his supervising officer, sergeant, and issue the citation within 3 days. The purpose of the statute was to do away with that, to get rid of a 3-day delay and require that someone issue it then, because those 3 days allowed for manipulation. In this particular case, my client didn't get the citation till 6 weeks later. 6 weeks later. There is more than ample opportunity for there to have been manipulation.
What kind of manipulation are we talking about in a case where here there was obvious signs of an accident, people were hurt? So what kind of manipulation are we talking about in this case as opposed to a case where you can't tell what actually happened and the police officer could manipulate things afterwards?
Any type of manipulation. In this particular case, there was no requirement that Mr. O'Leary be charged with operating under the influence, for example. That was a determination that Trooper Gray made. That's not, the Commonwealth hasn't substantiated that OUI charge with a blood alcohol test, with a breathalyzer, with anything. That was a determination that Trooper Gray made. He could have issued an OUI. He could not have issued a charge of OUI. That was his discretion.
Remind me, weren't there signs of intoxication? Or
according to Trooper Gray, who made the factual determinations, who made his own claims, that Mr. O'Leary admitted to having 2 beers, and that I think that's it. I think that maybe there was an odor of alcohol. Regardless, those issues of fact, when examined by Judge Cannoni, she determined there was no reason. And the appellate court's majority decision itself says, well, there was no good reason. And Judge Agnes's dissent accurately points out, no, there was no reason. To say no good reason is a pass. There was no reason. Trooper Gray could have done so. And that's the exact issue. I mean, any manipulation could have happened in that amount of time. And that the whole point of the statute is to disallow that amount of manipulation to occur.
So now, I'm sorry, give us your third before it gets lost.
Mm-hmm.
Yes. So sorry. So just the second piece that
Requires a writing, concerned about fixing citations, and the third is?
And the third is the as soon as possible element, which is also raised by Judge Agnes, and which I think is of the import. If the Commonwealth's argument is to be believed, and there was some reason some imaginary reason that speculative reason, I'll say, why citation could not have issued at the time and place. This court has said time and again that if a citation does not issue at the time and place of the accident, it must issue as soon as possible thereafter.
So does it ignore in that analysis to the detriment of the Commonwealth that the zip code was off?
Right, so, and this court has already said that 4 days is already too long. Ooh, sorry about that 4 days is already too long. So a delay of 4 days is not as soon as possible. And that was Commonwealth v. Carpolucci. This court, the Supreme Judicial Court, has already said that. 4 days is too long. In this case, Trooper Gray argues it was only 9 days. That's the Commonwealth's argument. It was only 9 days before he issued the citation, and that it was then not 6 weeks until he got it because of the zip code issue.
Right.
Even if
Can we go back to Justice Budd's question, though? You've got, I don't think there's much surprise by this defendant, putting aside what Ms. Murphy said, that there's a summons coming in the mail. And a matter of fact, the trooper at the hospital says that. The car flips over 5 times or so. He lies about whether he's driving or whether he's the passenger. And how many prior OUIs does he have? 3, 4, 5? How many?
I believe that this is charged as a 50 OUI. However,
It's a big surprise that the summons is coming in the mail to deal with the no fix.
A very good question, and this is something that I address extensively in my memo, and I want to make a specific point, 2 points to that question. First of all, Judge Cononi made a ruling of fact. She heard the witnesses. She also, I think, was aware that the Commonwealth in this case argued that the accident was not that bad. In the March 18th, 2015, the Commonwealth, in its motion suppressed, was compelled to argue, because it was a non-custodial interrogation of my client, that the accident was not that bad, that he was free to go, that he could have left. They prevailed in that argument. Now, in a motion to dismiss, they flipped their argument and said, no, he was badly injured and there was a serious accident, and so he should have known. But then they have to flip the argument, the factual analysis again, and say, oh, but the verbal warning was enough. Even though he was injured, and we just said he was badly injured, before that he said he wasn't badly injured, now we're saying he's not badly injured again because we're saying he had the wherewithal, the mental wherewithal, to understand the oral statement, despite the fact we have a factual analysis by Judge Cononi who says that was not credible, that Mr. O'Leary's surprise and lack of understanding about what he was going to be charged with and if he was going to be charged, she credited that testimony.
Well, I think
she credited that factual
analysis. She credited the Officer Gray that he said it. She also credited Mr. O'Leary that he didn't understand it at the time.
And again, in the end, the statute doesn't have an asterisk or a caveat saying, well, as long as they make an oral statement. If the officer makes an oral statement and then that's understood, that's good enough.
How's this case
That's not what the
different from
statute
Cameron?
says. The statute says
Sir?
there must be a writing. Sorry.
How's this case different from Commonwealth versus Cameron?
Commonwealth v. Cameron, it's significantly different in many respects from Commonwealth v. Cameron. First of all, in Commonwealth v. Cameron, it wasn't a one-party accident. In Commonwealth v. Cameron, the car crossed a double line, struck a pedestrian. That pedestrian was then flung 43 feet, severely injured, went to the hospital, and there was a question about whether he would die or not. In this particular case, the Commonwealth has submitted to the court in the motion hearing no evidence whatsoever, no medical evidence, no medical documentation whatsoever that there were serious injuries. She calls them serious injuries time and again. This court has determined a serious injury is a
Did you say
life...
he was boarded? Wasn't he?
I'll get to that. This court has said that there's a life-threatening injury is what a serious injury is. And yes, Justice, absolutely. He was boarded at the scene and taken to the hospital. He was released the same night. He spent hours in the hospital. And again, it's not my burden to prove that the injuries weren't serious. The burden is clearly on the Commonwealth. as they admit to, especially when there's no writing has been issued.
So the difference is the seriousness of the accident.
So one, seriousness of the accident. Two, it was an unknown additional party that was there. Three, the delay was 3 days. We've already determined, this court has already determined 4 days is too long. Perhaps 3 days isn't. But if 4 days is too long, 9 days certainly is. And Cameron, the delay was 3 days. Maybe that's enough. Additionally, in Cameron, the police officer was waiting for something. He was waiting to determine if the boy was going to live or if he was going to die. Judge Cannoni, in this case, made a factual determination, uncontested by the Commonwealth, that Trooper Gray's investigation was over when he left the hospital. There was nothing else left to determine. In Commonwealth v. Cameron, there was something rather significant left to determine, whether a boy was going to die as a result of the injuries.
So this is sort of like a get-out-of-jail-free card.
I wouldn't say that, Your Honor. I wouldn't say that that's a get-out-of-jail-free card. What I would say is this. If we have a democracy and we have a rule of law, we have to adhere to the statutes that are written by our legislature, that are written by the democracy. That's what we have to do. We can't just say, well, in this particular case, we don't like the outcome, so we're going to ignore the statute. We can't say, well, in this particular case, there was a search and seizure that we didn't like, or there was some area of law
Well,
that
it's not as clean as that. There's 3 exceptions. You went over them.
Yeah, I went to the exceptions. Exceptions of...
I mean, it's not, I think your response is, there's 3 exceptions.
But those exceptions only apply to why a writing can't issue at the time and place. Even if those exceptions apply, even if you have one of those 3 exceptions, then you must issue the writing as soon as possible. So if we're going to say, fine, there's an excuse why they didn't do it then, there is no exception to the as soon as possible language. You must do it as soon as possible, no exceptions. And this did not happen in this case.
What's to do it? Is it write the citation or have it received?
And I think there's a question about that, and it's gone back and forth because very often the citation is handed to someone, even if it's 2 or 3 days later, they find the person and they hand it to them. So I think I think that's a good question that hasn't actually been addressed by any of the cases that I've read. But inarguably, as soon as possible is not 9 days later. Carapellucci said 4 days is not as soon as possible. And I'll point out, in Carapellucci, the defendant went missing. They didn't know where the defendant was, and they had to find him. And then once they found him, which was not until weeks and weeks after the incident, this court said that once they knew his identity, the fact they waited 4 days, even though it had been weeks before they finally figured out who it was and sent the citation, 4-day delay is not as soon as possible. So there was unequivocally an exception, one of those exceptions. But that exception, again, only applies to the first half, the at time and place. There is no exception to the as soon as possible rule. And the Commonwealth simply did not comply with it. And I'm out of time, so I'll make this remark in closing. If this appellate decision is allowed to stand, then there is no statute. The appellate court will have effectively destroyed the statute. The statute says it has to be at the time and place or as soon as possible thereafter. It was not at the time and place, and there was no reason why, and it was not as soon as possible thereafter, and there was no reason why. The Commonwealth says, well, give us a break because we're the government and we should be trusted, and it's fine. He should have known that it was coming anyway. That's not what the statute says.
All right, thank you.
Thank you.
Ms. Alford?
Thank you, Your Honors. Pamela Alford for the Commonwealth. Today, we ask this court, as did the appeals court below, to reverse the motion judge's order allowing the motion to dismiss because the purposes of the no-fix statute were not thwarted. The purposes of the no-fix statute going back to the legislative history was to prevent manipulation and misuse and create a non-criminal system for the fleeting nature of traffic violations. There was nothing non-criminal about what happened. This case was indicted, and this defendant receives all the due process procedures and accommodations and entitlements that indictment and that criminal charge.
You never argued that it applies only to civil matters. This is the first time you've made that argument. You didn't make it in your briefs.
This is certainly the argument I've made in my brief. It goes back to
It does not apply to criminal matters?
Your Honor, I am not saying that it doesn't apply to criminal matters.
You
I'm
just did.
saying going back to the purpose of the statute.
Right, and the purpose of the, but you...
Going back to BAB.
Okay, but I'm trying to figure out, you know that this statute has been applied time and time and time again with regard to criminal violations, correct?
Absolutely, and it all goes back to whether the purpose of the statute was frustrated. And I'm saying that the very serious nature of the charges, which is argued in my brief, fills both purposes of the statute, both the no-fix purpose of the statute.
How do they, well, let's go to the statute.
All right?
Statute, let's put aside whether or not there was good reason for him not to hand him the citation in the hospital. Okay, well, the judge found differently, but let's give you that. Then it shall be recorded upon a citation as soon as possible. And there's no dispute that 9 days is not as soon as possible, correct?
I would say as soon as possible goes back to whether the purposes of the statute
Okay,
were
I'll
frustrated.
try my question.
Yep.
The statute, we're bound by the statute, are we not? The legislature made a decision that for whatever, that being in part because of the concern about fixing citations, the concern that someone's going to make a telephone call to the police department after an accident and say, cut my friend a break. So the argument is it wants there to be a written citation as soon as possible after the accident to prevent all that stuff potentially from happening. Isn't that the reason why they eliminated the 3-day rule and moved to an as soon as possible rule?
Absolutely. And to bring traffic offenders uniformly to justice. And here we would have the perverse result that somebody charged with OUI 5 and operating after suspension would not be brought uniformly to justice. And I would say we are constrained by this court's interpretation of the statute. It goes all the way back to BAB, which this court said where the purposes of the statute are not thwarted, strict compliance is not necessary. It goes back to the legislative history.
So I'm trying to figure out, this is an argument I've never heard you make before. You're saying it does not apply to OUIs?
I'm not saying that. I'm
So
saying you go to each.
what are you saying? What does it not apply to?
It does not apply to this case where the very serious nature of the charges created in a radical record of the event. If you look at this court's language in Carapellucci, which was not a 4-day delay. In that case, which was leaving the scene of property damage and personal injury, a citation never issued. And what this court said was that it was not such a case where the serious nature of the injuries created an erratical record of event, and that strict compliance
created an erratical?
I apologize. Erratic. Non-erasable, if I'm stumbling over the word, Your Honor, I'm sorry.
Not erasable, but there was nothing written in this case until 9 days. I mean, it requires there to be the recording of a citation.
It does as soon as possible. And this is not a case such as the appellate court in Burnham, where there was no indication of intoxication, and then several months later, the police realized there might be some issue of intoxication. This is a case where things were always moving. First, it was not reasonable to give a citation at the scene. This was a busy accident scene, an exit ramp was closed, an exit sign was dislodged, and both...
I'll grant you that for now. For me, the issue, if that was the issue, in my mind, you'd probably win. Where I am stuck with is the legislature says in such case where it was not where you couldn't do it at the scene, the violation shall be recorded upon a citation as soon as possible after such violation. And there's no dispute that it was not done as soon as possible. So
Because
how do we abide by the statute if you're right?
Because you look to the purpose of the statute. You look at, and Your Honor, I do want to make very clear to answer your question, I am not suggesting that this case does not apply to all criminal charges. I am suggesting you look at the facts of this case and the very serious criminal events and criminal charges, and not to mention the operating after suspension charges, a number of them, including operating after suspension when your license was revoked for operating under the influence. And the importance of those charges is that you have to have notification that you were driving after your license had been revoked. If you go back to this court's decision in Commonwealth versus Giano, which was a case of, I believe, use without authority, one of the holdings of this court was that it was superfluous, it was superfluous to tell a traffic offender who knows that he's not supposed to be using a car without authority to give him a citation to tell him you're not supposed to be using a car without authority, because that goes back to the purposes of the statute, the notice provision of the statute.
Right, but the fixing provision, you only attempt to fix a citation when you know you're going to get it. So the fixing purpose, which is, as far as I can tell, the primary purpose, is separate and apart from notice.
Because the 3-day provision was to take away supervisor's discretion for a uniform, non-criminal system. I suggest it is a perverse result to say that in an incident, in a crash where it's nothing but fleeting, to say that the purposes of the statute were not met. But when the individual was mailed a citation, the radical record of event, within 9 days after an investigation, the trooper absolutely, as found by the court, told the defendant at the time that he was going to issue a citation. I disagree with my brother that that the Commonwealth is the one who is flipping their position at the motion to suppress. The motion to suppress was denied. Certainly to suggest that the findings were not suppressible at the hospital, but then that the defendant did not have notice, I suggest it is not the Commonwealth's change in position. If you look at Cameron, I suggest, as what Justice Budd related, is directly on point here, that justification is not just how good of a reason does the trooper have. Justification goes back to the purposes of the statute. And Cameron says, in BAB, we suggested that this statute was not a complete defense, and I'm paraphrasing, and they've amended the statute since then, and they've not changed that provision. So we have accepted that the legislature has agreed with BAB's take that the purpose of the statute, that where the purposes of the statute was not thwarted, that strict compliance is not necessary. And here you have a defendant who created a large accident scene, who lied at the scene, who originally lied to the trooper.
I understand. He's he committed a crime, and in a better world he should be prosecuted. But I still have a problem that the legislature has language which you want me to rewrite. You want me to say it does not apply, it applies only with regard to traffic citations, and you say, no, it applies only in... I don't see any of these exceptions built in to it. And the question is not whether it's a wise statute, the question is whether or not we should be rewriting it. You may not like... Suppression can be a hard remedy. It can result in people who should be convicted not being convicted, but it is a remedy imposed by law. Here's a remedy imposed by statute, which was designed to prevent the fixing of citations.
And allowing the motion to dismiss here does nothing to further the purpose of that statute. I am not asking Your Honor to rewrite the statute. I am asking Your Honor to issue a ruling consistent with this court's ruling in Cameron and Babb.
Which would say?
Which would say that here where the accident was very serious, where the defendant received oral notice, where in Cameron there was also a finding at the appellate court level that, and I believe at the trial court level, that the defendant was not on notice. This is not a factual finding. This is whether notice was sufficient. It's an application of facts to the law. And this court overturned the appellate court decision in Cameron, which said the defendant was not on notice because he was in shock. And this court said, where there was an immediate accident, where the defendant ran away, it is not reasonable to conclude he was not aware of the seriousness of the accident. And we look at justification not just at how good of a reason the trooper has for taking extra times, but whether the purpose of the statute was met. In Cameron, the trooper had a couple of days off. The trooper also was under the mistaken, thought that the victim might...
But there's no excuse here. The purpose of the statute would have been perfectly satisfied if he had the next morning issued a citation.
And the trooper...
I mean, how do we... There's no justification for the 9 days, correct?
No, I suggest the trooper did say that he found information as to the criminal history during his process of writing a report. Again, he's writing a report. He's writing an erratical record of the event that somebody could access, that the trooper is still acting to go forward to provide prompt notice. And I recognize that there was a problem with the address. The trooper testified
Put that
of
aside.
how that happened.
I'm speaking about the recording of the citation. So the statute says the violation shall be recorded upon a citation. Put aside the screw-up with regard to the mailing. It was not recorded upon a citation for 9 days, not because of Gray, I gather, because of his supervisor took 8 days to review it. I gather.
The record is unclear on that point, Your Honor.
Okay.
But he said that the process took 8 days. He put it in the mail at that point.
Okay, so what do we do with that sentence? In such case, meaning in case where the exception is justified, the violation shall be recorded upon a citation as soon as possible. So you say, well, I think you have to realistically concede this was not as soon as possible, but you say we should ignore that obligation because it was a serious offense.
Because it was a serious offense, because he had implicit notice that charges would issue, because he was charged with crimes for which notification was an element, thereby rendering a citation superfluous to whether he should be on notice that he was going to get charged.
I understand that, but the notice, you have an incentive to fix only when you have a notice that they're going to file a citation. You wouldn't fix it if you didn't think they were going to file a citation.
But then how
That's
does
when you
that...
make the telephone call to say, cut me a break here. It was, that's the legislature here is doing a prophylactic prevention of the problem that it saw when it passed the statute of people seeking to fix citations. So it said, get it written, do it right away before the fix can come in.
For two reasons. One, so that you have the ability to have a defense for a fleeting traffic violation, of whether you were speeding, whether you took a right-hand turn, which is worlds away from what happened here. That purpose simply isn't met. And two, so you cannot make that call. And I suggest this is a perverse result, and this court has previously addressed this issue in Cara Palucci and Cameron and Babb, that the no-fix purpose isn't met when the no-fix purpose is not at issue, where it is a very serious accident, where it cannot be thought that the trooper had any discretion but to issue a citation, but to pursue charges, and it's the Commonwealth's position that this is precisely what happened here, that we are not asking you to rewrite the statute, but we are asking this court, as did the appeals court, to act consistently with this court's previous interpretations of the no-fix statute of Cameron and Babb into, as did the appeals court, reverse the trial, the motion judge finding, allowing the defendant's motion to dismiss. There are no further questions?
All right, thank you.